All right, great. We are recording now. I've actually begun the lecture, and I forgot to hit record. So I've now hit record. This is our last lecture. And I've been talking about whether Facebook is an illegal monopoly. And I just want to sum up here and just say, look, to establish whether Facebook is an illegal monopoly or any company is an illegal monopoly, the government, in this case, it's the Federal Trade Commission that brought in action against Facebook on December 9th of 2020. The government has to show these two things that I've been talking about. One, that the defendant, in this case, Facebook, that they have market power in the relevant market, that they are in fact a monopoly, right? And that right there is going to be a very hard fought legal question, because although Facebook does own Instagram, and Instagram is very popular, right? Facebook has made so many changes to Instagram, and Facebook itself, though it's the most dominant social media platform in the world, in the US, right, where this case is being brought, Washington, D.C., Facebook is kind of falling off, especially among younger people. Let's be honest, Facebook is no longer cool. And to some extent, that's happening with Instagram, although Instagram is still very popular, you know? But there's a whole bunch of other things out there like TikTok, Snapchat, things I don't even know about, you know, things that will probably blow my mind if I were to look at these things. And so does Facebook even have market power in the relevant, social media market? What is the social media market? And because social media is worldwide, right? Anybody can join as long as they have a Wi-Fi connection or internet, right? Internet connection. As long as they have an internet connection, anybody can join any social media platform, right? That's going to be a tough battle. But also the government has to prove then that not only does Facebook have market power in the relevant market, i.e. Facebook is a monopoly, but that Facebook did commit some illegal act. And that's going to be decided under what courts call the rule of reason. So courts will weigh whatever harm to competition generated from these illegal acts. They have to weigh that against the benefits to consumers. And because Facebook, nominally provides all of its stuff for free, because what they really want is your data so that they can then market your data to third-party advertisers, right? Who knows? Who knows? Because there's a big allegation here that the illegal act that Facebook is committing is not really taking care of your data, and making sure that it's not, abused or manipulated or sold off to other parties. So we'll see what happens with this case. I just want to establish that it's a very uphill battle for the government. All right, the next thing I want to talk about is corporate governance. Really quick here. One of the things I like about the social network is that it shows you how Facebook evolved as a company. It begins as a sole proprietorship. There you have Mark Zuckerberg, hacking Harvard, creating this. I thought it was a pretty cool website, the FaceMash website, where people can rank each other. And I was going to tell you something about I forgot to mention when we had that first class on hacking and the FaceMash. There's a new thing out there called lookism, that people who are better dressed or more attractive get more benefits than people who are not as well dressed or not as attractive. And how do we deal with lookism? You know what I mean? But what's interesting is with FaceMash, lookism, that's what it was based on. Who is the hottest student at Harvard. Then Zuckerberg after that becomes partners with Eduardo, right? Then after that, it's briefly in the movie in one of the deposition scenes. Mark and Eduardo bring on Dustin Moskovitz, and they create a limited liability company. A limited liability company is just like a partnership, except that there's limited liability. Partnerships don't have limited liability. Partners are personally liable for all of the debts and legal obligations of the partnership, and in fact, of their fellow partners, in connection with the partnership business. So limited liability company, what happens is the partners, instead of calling yourselves a partnership or a partners, you are now members of the limited liability company. And then the members can either, manage their own limited liability company the way the Facebook did, or they can appoint a manager to manage it for them. And that's how other LLCs do it. So LLCs have a lot of flexibility. And finally, there's the corporation, right? Today, Facebook Inc., major, it's a US corporation, right? Incorporated in Delaware, but it's sort of like, when you want to go public, you want to convert into the corporate form so you can sell shares, right, on secondary markets. And those of you who study finance, right, will know all of the advantages and disadvantages of these various ways of doing business. What I want to focus on here is on the legal side and show you is when we talk about corporate governance and what's the advantage of a corporation over all of these other forms. Because a corporation, like a limited liability company, right, gives shareholders limited legal liability protection. But the main advantage is this. The main advantage is going to be what we lawyers like to call the separation of ownership and control. So ownership, legal ownership of the corporation belongs to the shareholders, right? And your ownership share is a function of the number of, shares that you own. But every year you elect the directors, and then the board of directors, they actually run the company. They appoint the officers, right? And then establish policy for the corporation and for the officers to follow, and then engage in oversight over the officers. So that's what we mean by the corporate governance. What Facebook has done really interesting, and this is true of all corporations, and this is considered the main advantage. What's really interesting in the case of Facebook is they're involved in all of these controversial, Facebook, just by the nature of its business, if they keep Trump up, that's a terrible decision, right? How can you, take that chance after January 6th insurrection? But they kicked Trump off. What? This is an elected leader. How can you kick off an elected official, from your social media platform? Now, I will tell you, this raises a whole host of fascinating, controversial First Amendment issues. Here I have something, the Facebook board, but let me just, before I talk about the oversight board, let me talk a little bit about the First Amendment. What's interesting here is that Facebook as a privately owned company, right, it's owned by its shareholders, right? The First Amendment only applies to the government. It doesn't apply to private companies unless the private company is providing a public service or a public function. Unless that public company is itself acting like the government or providing a government public service. This is the controversy today with social media, because you could argue, yeah, of course, Facebook is a privately owned company, and that's great, but because people use Facebook to exchange ideas, I know I've seen, and I've even seen debates, the Puerto Rico debates for a governorship. I saw those debates on Facebook Live. So because Facebook is providing its platform to allow people to, exchange political ideas, you could argue that Facebook is very much acting like a public square, providing a public service. And therefore, we should apply the First Amendment to Facebook, to the extent it's providing this public function. Just like the government has to. The government has a public square. They have to allow everybody to speak. They can't censor speech. then you could argue the same should apply to Facebook and the electronic public square. I personally find that argument very, very persuasive, and I only think it's a matter of time before that case goes up to the Supreme Court, and the Supreme Court says, yeah, of course, this is obvious. Facebook is acting, providing this public function, and we're going to apply the First Amendment. But what I want to share with you is this. That's going to be very controversial, because under existing First Amendment law, for example, hate speech, at least in the US, this is not true in other countries, but in the US, hate speech is protected. The only types of things that aren't protected under US First Amendment law are going to be threats of imminent violence, obscenity and child pornography, things like perjury and defamation, those narrow categories. That means, right, if the First Amendment does apply to Facebook, then Facebook cannot have its quote unquote community moderation policies anymore, right? Because those community moderation policies are actually very strict about hate speech, and under the First Amendment, you can't regulate hate speech. You have to allow people to say whatever they want to say, as long as there's no imminent threat of violence, or it's not defamation, it's not perjury, and it's not some type of obscenity or child pornography. So, this is to me the great conundrum of free speech law. Facebook, nobody really likes Facebook, right? You're either upset that they kicked Donald Trump off for 2 years, or, you think that's great. They should have kicked him on for longer. You know what I mean? But notice under the First Amendment, right, they probably couldn't kick Donald Trump off at all, right? And so it would be, I just want to throw that out there. That it's not obvious whether, in fact, we really want the First Amendment to apply to Facebook and to these other social media companies like Twitter, or whether we prefer Twitter and Facebook just to unevenly enforce their community moderation policies. I myself, got to say, personally, I'm very frustrated by YouTube and Facebook. It's clear they have this double standard, right? You can't talk about the Wuhan lab leak. Come on, give me a break, when the evidence is pretty persuasive that that's, it's a 50% probability that's how the coronavirus began, So it's like, I don't know if I personally like these companies telling me what I can and cannot say. Should kids wear masks? What do you mean I can't post a video saying that kids shouldn't have to wear a mask? You know what I mean? When all the scientific evidence seems to say that kids, don't really need to wear masks. So it can get, we'll see. I'm going to try to post this video up to YouTube later, so we'll see if this works. All right. Don't want to throw that out there. The thing I want to know that's really interesting about Facebook, and I have to give credit to Facebook, is this oversight board I was telling you about. I think Zuckerberg realizes that whatever decision he makes when it comes to Donald Trump and, all these, coronavirus conspiracy theories, pandemic, he's created this oversight board so that if any of the users want to appeal a decision that, hey, I can't post up my content on Facebook, I can appeal that decision to the oversight board. Now, I will tell you, the oversight board has full discretion over its docket, so they're not required to take your appeal. They're only required to take an appeal if Facebook is the one asking for the appeal. So when Mr. Zuckerberg banned Donald Trump from the platform, he himself asked the oversight board to then review his decision. And the oversight board, they're appointed separately from Facebook, and they organize themselves in small panels of 3 to 5 members, and they make their own decisions, and Facebook has agreed in principle to abide by the decisions that the oversight board makes. Now, I think in the case of Donald Trump, the oversight board decided that, they decided to actually, and I was surprised, but they decided to affirm Facebook's decision. So yeah, Facebook, you were correct to kick him off your platform, but you need to be consistent with due process. You need to set a time limit as to how long you can kick him off your platform. And then I included a link in the last module. Facebook then decided to impose a retroactive 2-year ban. So Donald Trump can't use Facebook until January 7th of 2023. So if you think about it, right, that'll be around the time that he'll be running for president again, assuming he does run for president again, and then he can use Facebook again. So, very fascinating stuff, this oversight board. Again, let me say it this way. I give Zuckerberg a lot of credit, right? What other business person or CEO would say, I'm going to create an independent board, fund it $160 million, agree ahead of time, I will bind myself to its decisions for at least the next 5 years, and then if the experiment is successful, they'll renew it again. So this is to me, it's very unique, never in the history of, corporations has a corporation said, we're gonna create an independent board and allow that board to review our decisions, and we're gonna agree ahead of time to abide by the decisions of that independent board. So that's like I'm saying, I give a lot of credit to Mark Zuckerberg. But let me tell you, the devil is in the details, as they say. And some of the criticisms of the board has been as follows. One criticism has been that the board is only allowed to review takedown decisions or decisions to ban people like Trump. The board, if Facebook decides, like let's say Facebook had decided not to take any action against Donald Trump, the board would not have had jurisdiction in that case. The board only has jurisdiction when Facebook decides to take something down or to censor someone on their platform, So it's kind of an asymmetry there. I would argue that's a necessary asymmetry, right? You got to focus on those trouble spots. But critics have noted that, a lot of Facebook's most controversial decisions is like with Donald Trump before January 6th, when they decided to do nothing, when they decided just to leave the stuff up there, And I think Zuckerberg said, like, we're not going to review like political speech on our platform for its truth value. I think Jack Dorsey on Twitter has said, we're not going to allow any political advertising on our platform. But Facebook is taking a different approach. So just want to throw that out there, but I think it's a step in the right direction, personally. All right, great. Now let's do part 3 of the class. Last part of the class, I want to talk about corporate social responsibility. And what I've done there is that's a different slide presentation. So let me see if I can find that and pull that up. Oh yeah, here it is. Good. And then we can start concluding this class, this summer A semester. All right, here we go. Oh, by the way, before I do this, well, just go ahead and jump in here. Let's not do any further delays. Now, let me see, how do I move this thing? Let me just grab a little bit of water before we begin here. I want to conclude on corporate social responsibility and the Accountable Capitalism Act. And then we can just wrap up the semester. Now, when we talk about corporate social responsibility, I want to make it clear there's actually 2 schools of thought, or 2 models, if you will, 2 theories. The moral minimum model and the stakeholder theory. Now, I will tell you, these theories have different labels. Sometimes stakeholder theory is called good corporate citizenship. Sometimes people just confuse corporate social responsibility with corporate citizenship. But I'm here to say That's incorrect, because beginning with Milton Friedman, he very controversially, I would say personally correctly, but he very controversially argued that the social responsibility of business is to maximize profits. That's why I say these are two theories of corporate social responsibility. So let's do the first one. It's called the Friedman Doctrine, in honor of Milton Friedman. I should say, though, the Friedman Doctrine, its intellectual pedigree goes all the way back to the invisible hand theorem of the great father of economics, Adam Smith. And if you recall from your economics courses, the invisible hand is the idea that if you really want to promote the welfare of society, just allow everybody to pursue their own self-interest. It's when everybody is pursuing their own self-interest that you have the best benefits to society. And Milton Friedman, that's all he's doing, is just repackaging that fundamental observation made by Sir Adam Smith back in 1776 when he published The Wealth of Nations. The idea is that, and this is why, by the way, this is why Milton Friedman says that the corporate social responsibility of business is to maximize its profits. Friedman Doctrine, you're in business to make money, and so your ethical obligation, is to make money. That's what Milton Friedman is saying. It sounds a little bit shocking, but notice it's also called moral minimum, because Milton Friedman himself clarified that, of course, you have to act within the law, right? You can't commit fraud. You can't commit deceptive advertising. You can't commit unfair business practices, right? You have to play within the rules. So I want to make that very clear, that, it's not about making money by breaking the rules. No, it's about you make money, but you have to play within the rules. That's why, by the way, I can say with a straight face that the Friedman Doctrine, or maximizing profits theory, is one version of corporate social responsibility. Because what Milton Friedman is basically saying is that as long as a business complies with the law or doesn't break any rules, it has established its ethical obligations. It has met, I should say, its ethical obligations. Its ethical obligations, in other words, only go so far as to whatever the law requires. That's what Milton Friedman is saying here. All right. Now, it's a powerful theory, goes all the way back to Adam Smith. I have all this information here. But as a professor, I always like refuting things. And what's really interesting is that you could easily refute, the Friedman Doctrine or the invisible hand theory. I can refute it with a single meme. Pharma bro, right? I don't know if you remember this jerk off here, right? Who bought the rights to a medical patent, for people who had this rare disease. And then he jacked up the price of that drug 5,000%, I mean, that's perfectly legal, right? This guy is the embodiment of the Friedman Doctrine. And yet, of course, rightfully so, he is the most hated, despised man in America, right? Now that Osama bin Laden is dead, right? So it's like clearly Milton Friedman Doctrine, the invisible hand theory, is missing something. And I will tell you, even Adam Smith himself, before he wrote about economics, he was a moral philosopher. And Adam Smith, moral philosophy, he has something called the impartial spectator. When you want to decide whether something is right or wrong, it's not just, is it consistent with the law? You have to imagine, he calls it the impartial spectator. You have to imagine an imaginary judge reviewing your decisions. What would he or she say? would they say that's right to, buy the patent and then jack up the price in such an extravagant degree? You know what I mean? Adam Smith, to me, the real Adam Smith, probably would not be okay with this at all. Now, this takes us to then our second major theory of business ethics, or our second major theory of corporate social responsibility, and that is so-called stakeholder theory. And this model actually is very powerful and attractive. What it is you identify, okay, who are the stakeholders, right? Who are the constituents or the groups of individuals that would be affected by any decision made by the business? So, of course, I would always start with your customers. That's why you're in business for, right? Now, Milton Friedman would say, Milton Friedman and Adam Smith would say, and I would think, I would argue correctly, that this theory is completely redundant, because that's why we have markets. If you don't take care of your customers will go to another competitor or another business firm. So you don't need this stakeholder theory to tell me I got to take good care of my customers. But the stakeholder theory is saying, but yeah, it's not just your customers. What about your employees, right? What about the people you do business with, your suppliers, right? And your creditors, as those of you in finance know, it's not all equity. Some finance is debt, right? What about the local communities in which you do business, right? So stakeholder theory is basically saying that you take into account all of these constituencies before you make a decision. That's what stakeholder theory is. You don't just ask, okay, will this decision make the company money? You ask, will this decision negatively affect any of these stakeholders? And then presumably, if the answer is yes, you rethink the decision. This is a very powerful theory. And let me tell you, by the way, let me give you what I think is the most famous example of the stakeholder theory. Donald J. Trump, 2016, right? He ran on this whole platform that these American companies are shutting down their factories in Indiana and in Michigan, for example, and opening them up overseas or in Mexico. And that was, wrong, because that's going to negatively affect the employees and the local communities in which those employees live, and the rest is history, because some have even argued that this issue about workers' protection is why Trump won, like those Rust Belt states like Ohio, Wisconsin, Pennsylvania. You know what I mean? Because the workers like this message. Hey, somebody's looking out for us. It's not just about making money. It's about protecting the workers as well. So this is very, very cool stuff, if you ask me, right? Now, I will tell you, however, again, remember, I like to always, professor, so I like to find, fallacies. And I will tell you the stakeholder theory, as beautiful as it sounds, you know what I mean? And it is the dominant way now of looking at corporate social responsibility. It's why most people equate corporate social responsibility with the stakeholder model, and they forget about the Friedman doctrine. But there are some really big, gaping fallacies with the stakeholder model. The big one is that it's wishy-washy, to not say BS. Because notice what the model doesn't tell us, right? Go back to the original model. What weights do you want to assign to each one of these constituents? Are they equally weighted, for example? Well, if they're equally weighted, that is a problem, because what happens if the interest of some stakeholders are different from the interest of other stakeholder groups, right? What happens if you have a tie? What happens if you have conflicting stakeholder interests? What do you do? You know what I mean? And I think in the real world, you're going to have conflicting stakeholder interests. Even the carrier example I can use to illustrate what I mean by conflicting interests. Yeah, the employees lose if Carrier closes their factories in Indiana. But what about the customers, right? Is it really in my interest to pay an extra, what is it, $100 for a bill made in the USA HVAC unit? Or, why I want to pay, I don't mind if it's made in Mexico if I can pay for a cheaper price. You know what I mean? So how do you reconcile the interest between consumers and employees, right? So, that's, that to me is a problem with the stakeholder model, when the stakeholder model can only identify constituents or stakeholders, but doesn't assign any actual weights to them. With this, I want to conclude with the environment, with the Accountable Capitalism Act, because one of the things I like about the Accountable Capitalism Act is it calls BS. All of these companies, you may have heard of something called the Business Roundtable. And the Business Roundtable, I think last September, they said, oh no, our policy now is going to be to advocate for the stakeholder model. But then as I've explained, right, the stakeholder model is wishy-washy, right? Because you could basically generate any decision with the stakeholder model, because any decision that you make is going to favor some stakeholders and be against other stakeholders. So you get to decide, you still get to decide what you want to do. What I like about this Accountable Capitalism Act, though, it would just change overnight the existing legal landscape. And so Elizabeth Warren introduced this bill back in 2018 when she was going to run for president. And then she's reintroduced it now in January of 2021. Now, the big difference between January 2021 and August 2018, anyone know what that is? It's going to be that the Democrats now have 50 votes in the United States Senate, right? And continue to control the House, though by, I think, a very narrow, like 5 votes. So all of what I'm about to say is contingent on what happens in the 2022 elections, right? But the point is now that the Democrats have the votes, right? They can move forward if they want to with the Accountable Capitalism Act. Now, I will tell you and here's what the Accountable Capitalism Act, there's a number of things, but I want to focus on the 3 major things that the Accountable Capitalism Act does. If you go into the survey, you can vote on this, and then we'll look at the survey results after I describe this bill. The survey, the Accountable Capitalism Act would do 3 things in its current form. Number 1 is it would create a new office in the Department of Commerce. The office would be called the United States Department of Corporations. This in itself is the single biggest change that the Accountable Capitalism Act does, because now, since the founding of capitalism, corporations have always been a creature of state law. And most US corporations, for example, favor Delaware law. They want to incorporate in Delaware. But some corporations incorporate in California. Some companies incorporate in Florida. You pick a state and you incorporate in that state, right? What this bill would do, though, is say, no, wait a minute. If you are a company doing business in the United States and your company generates more than $1 billion in revenue per year, you also now have to register with the United States Office of Corporations. So that would be the first big change. It would federalize corporations law for the first time in our nation's history. Existing, I will make this very clear to you, because we didn't really get into securities regulations and secondary markets and all that advanced stuff that we do in the advanced topics course. Just know that under existing federal law, like the SEC Act of 1933 and the Securities and Exchange Commission Act of 1934, those acts only impose disclosure requirements. That is to say, under existing federal law, federal law doesn't really apply to you unless you decide to go public and offer your shares on the New York Stock Exchange or the NASDAQ, like Facebook has done. And in that case, then you have to make a series of disclosures to your investors, and you have to make those disclosures every quarter and every year. And so, and if you put false information on your disclosures, you could be legally liable under federal law. That's the existing scope of federal regulation of corporations, right? But Senator Warren's bill would federalize. You now have to get a federal charter. Number two is these companies that have $1 billion in revenue per year, 40% of their board would have to be rank and file employees or workers. Now, to appreciate this, let me show you Facebook's board of directors. Give me 1 second here because I closed the tab by accident. All right, good. And I'll go do a screen share here. Oh no, I do not want to leave the meeting.